take this order, so when I nod, it doesn't indicate anything. Okay. In general, in Arizona, there is a presumption in favor of disclosure of all public records. As a general rule, all records required to be kept under A.R.S. 39-121.01b are presumed to be open public inspection public records, Carlson versus Pima County. Importantly, under law, the reason the records have been requested is irrelevant.
Can you speak up and go a little slower, please?
Sure. With regard to
when you're reading.
with regard to whether disclosure is required, because disclosure is always required as long as they're not exempt. Under section 39-121.01b, it's required that all officers and public bodies maintain records that are reasonably necessary to provide an accurate accounting of their official activities and government-funded activities. So what is a public record? Now, that's been something that's been talked about here today already. Public record is quite simply all books, papers, maps, photographs, or other documentary materials, regardless of physical form or characteristics, made or reviewed by any governmental agency in pursuance of law or in connection with the transaction of public business. Now, what is metadata? Metadata is not data. Metadata is information describing the history, tracking, or management of an electronic document. Examples of metadata include file designation, create and edit dates, authorship, comments, and edit history. And I'll put forth, you'll hear testimony that that's really the bulk of what's been requested with regard to requests 5 through 10. And that definition comes from Lake versus City of Phoenix, by the way.
Your site?
I actually have the case, Your Honor, if you'd like.
I don't know who in the audience is related to which side of this controversy, but I'd like you both to instruct your observers that gestures will not be tolerated if they continue and ask security to escort those individuals out of the courtroom.
Madam Treasurer.
Yes, sir. Thank you.
Your Honor, if I may interrupt, now that that issue's been brought up, the defendants would invoke the rule of exclusion of parties, testifying parties,
Yes.
other than named parties.
Why don't you tell us who's here to serve as a witness and have that person stand?
Okay, we've got a couple of witnesses here. We have Professor Cruz EIC. He's going to be one of our computer experts. Let me have my other witnesses stand.
Just
Sergio.
remain standing, sir.
Yeah, and can I have Sergio? This is Sergio A.R.S.
Sergio what?
Arellano, A-R-E-L-L-A-N-O. Oros, hyphenated, O-R-O-S.
Okay.
I'm Michael Donahoe, D-U-N-I-H-O.
And this is our second computer expert. And we also reserve the right to recall either of our two experts. And we may or may not have John Brake. We're not planning on having John Brake testify unless he gets brought into it. But he is also here, so if you could please stand. With regard to...
He's the gentleman who can gesture.
Yes, with regard to...
Conversation.
Conversation with him. And we also have, if you're a named plaintiff, would you please stand and introduce yourself as well? Okay. Please introduce yourself as well.
Jack Skolnick.
You can have a seat.
And
Henry Olguin.
Robert? I'm sorry, your name's back there, sir. Did you say Sergio Odin?
No, Henry Olguin, O-L-G-U-I-N.
You can have a seat, sir.
Excuse me?
Go ahead and have a seat.
Olga
Go
Valdez.
ahead and have a seat, ma'am.
Robert Rojas?
Go ahead and have a seat, sir.
Cesar Parada, P-A-R-A-D-A.
Thank you.
and they're here exclusively if necessary for the testimony that they ask for the request to be submitted.
Mr. Brake, you can have a seat, and if you three gentlemen would raise your right hand, and I ask that you be sworn.
Okay, I'm sorry.
Always be sure.
Okay. Do you solemnly swear the testimony that you will give in the near future, or about to give, in the matter before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Thank you. You're all excused into the hallway until you're called to testify. Please don't discuss amongst yourselves any testimony to be given. when we have discussions with the lawyers. Now, for the county, do you have any witnesses?
Your Honor, only the two named witness, defendants Melinda Meek and Susan Sines, and also Raul Mavis, who is not in the courtroom, I believe.
Who was the third name?
Raul Mavis.
Let's have, Ms. Meek and Ms. Sines raise their right hands to be sworn.
Do you solemnly swear the testimony that you will give in a matter before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ladies, can we have a seat?
May I proceed, Your Honor?
Yes.
Okay, so is metadata a public record? Again, we would report that question has been definitively answered by both Lake and Pima County Democratic Party, that metadata is indeed a public record. And even if those cases were not enough, the very definition of data, excluding form as a consideration, would state that metadata is a public record. So how does all of this work together? Okay, so if granted, plaintiff's request is not going to reveal one single bit of information that could compromise the security of the counter's network, and you'll hear expert testimony today to that effect. Or one single bit of data that would compromise the integrity of the election process whatsoever. And that's what we mean when we say we're requesting metadata and not data. Okay? So let us clarify what is not being requested. Plaintiffs are not requesting any information that could identify any voter. Plaintiffs are not requesting any information that could identify a single vote. Plaintiffs are not requesting any program or access to any program. Plaintiffs are not requesting any source code. Plaintiffs are not requesting any software code. Plaintiffs are not requesting, as we've stated, any data at all. Okay? All that they are requesting are the lists that we ran off with regard to the tracking and the auditing that Arizona law clearly allows. Now, computer systems can be a little bit frightening to lay people, and so the county could be forgiven for failing to grant.
I'm sorry, sir, can you go a little slower?
I
Now,
apologize,
computer
sir.
systems, what?
Now, computer systems can be a little frightening to lay people, and so the county could be forgiven for failing to grasp the benign nature of this request, except that plaintiffs, in a series of meetings to which you'll hear testimony and written correspondence stretching over 2 months, repeatedly attempted to explain the benign nature of the requested accounting. And we've already entered in many documents into the record, and after we're done, we'll ask for stipulation that those documents be entered as exhibits. And today you're going to hear testimony about the pains that plaintiffs took to attempt to resolve this issue through explanation and not litigation. So far, I've been speaking entirely about requests 5 through 10. The public records request, as you know, is divided into 10 items. 5 through 10 I expect to be the main points of contention today. Those are the various items of metadata. Requests 1 through 4 are for more conventional forms of information. For instance, contracts, vendor contracts with ballot printing companies, intergovernmental agreements, things that are clearly required to be kept by the county in the ordinary course of business and quite clearly qualify as records. And A.R.S. 39-121.01c and 41-151.14b make it clear that the county was obliged to make and retain these records, containing adequate and proper documentation of the essential transactions of each county agency. Again, we said those clearly qualify. So therefore, the plaintiffs are seeking the following classes of relief. First, the granting within 48 hours of the records request in full. And if the county persists in denying, as it has, that they do not possess documents 1 through 4, that the court ordered them to obtain signed copies from the counterparties.
Signed copies of the what?
Of documents 1 through 4 from the counterparties. Plaintiffs are also requesting their attorney's fees pursuant to A.R.S. 39-121.02b and double damages and expenses pursuant to A.R.S. 12-349 because defendants have, as you will hear testimony again, unreasonably delayed what should have been a simple records request and have persisted in both denying, vacillating, and later defending this action without substantial justification. Your Honor, this case has technical aspects, but the central issue here is anything but technical. The people have a right to know how their elections are being administered. And at the end of the day, it is not the county's data, it is the people's metadata.
Thank you.
Your Honor, we live in a society that's at the mercy of computer programs. Driving this morning, I was thinking about the fact that there's hardly any cars on the road that even have a carburetor. You get the check engine light, you're in trouble. You have to go into a shop, they have to do an electronic diagnosis, and that's how you're going to get your car fixed, because you can't pop the hood and check it yourself. You know, and we live in a society where we've got international attention to Edward Snowden. We live in a society where Home Depot's credit card information has been compromised. And based on all of that, Your Honor, the county is right to be extremely concerned about sensitive information. We've got identity theft. These are all of the things that are coming into play with the county's determination on what to do with public records requests. First of all, I do agree, and I appreciate the fact that council has cited Lake v. the City of Phoenix, because I was planning on doing that as well. And from that, he's referenced the definition of metadata. He's also referenced the definition of data. And fundamentally, I agree with those definitions. What I have trouble with, Your Honor, is equating what has been requested as metadata. Again, metadata is information describing the history, tracking, or management of an electronic document. Basically, when I think of metadata, I think of you have a document, and the document, what it says is the document. You can print it from a computer, and that's what it is. The metadata is when that file was created. The metadata was who printed that file, on when it was modified. That's metadata, Your Honor. And public records, which again, hopefully is something that the court and parties can understand. It's very easily explained. The concern that we have at this point, Your Honor, is that what has been requested isn't metadata. Furthermore, the concern is that what has been requested isn't even a public record, because we're not asking for the printout history of any records that the Board of Supervisors keeps as part and parcel of the meetings that it has on a bi-weekly basis. We're not talking about internal HR documents. We're talking about the inner workings of the ballot box tabulators, the equipment that measures and tests, the equipment that tabulates the elections. And if you look at items 1 through 4, the state eventually, not this time, but the state eventually may concede that items 1 through 4 are indeed public records. The defendant timely responded to those public records with the denial that they even existed or that they had them, or we can kind of deal with 1 through 4 later. And again, I assume that we can dispose of that. The court will be able to do that rather simply. The problem with requests number 5 through 10, again, the defendants aren't convinced that it's metadata, data, or even a public records, because what was requested are event logs, audit logs, file allocation tables, program file folders, and probably one of the most troubling, to me at least, in thinking about it this morning, is network settings. When I think of network settings, I instantly think of security settings. The way that we vote here in 2014 is we have different precincts. I believe there's approximately 60 different machines throughout the county whereby people can go to vote. Those machines tabulate their results and then wirelessly transmit those results to the main hub that calculates who the winner was and who the loser was. That's how it works. So at this point, we have a plaintiff, and again, plaintiff is correct that we don't need to question their motives, but the county has been confronted with the plaintiff saying, hey, you know what? Your system could be vulnerable to cyber attack. And your system may not be in the best interest of the county. Somebody could monkey with it and really mess up an election. That's how the county's been approached. And you know what? We'd like to make sure, we'd like to confirm whether or not everything's on the up and up and being administrated appropriately. So why don't you go ahead and give us these documents? And the documents that they're asking us for, again, I agree with counsel, it doesn't matter what form they're in, but when you're asked for network settings, program file for folders, audit logs, event logs, file allocation tables, that's different than asking for minutes of a meeting or emails exchanged between public employees. That's asking for something that, again, not everybody understands. It's the fuel injection system in your car that makes your car go. And the county is right to be concerned about that. And the county at this point isn't taking the position that, you know what, you're not entitled to this information. The position that the county is taking is, we simply don't know, and we don't have sufficient information to decide whether or not, number one, that is a public record, and number two, whether or not it's in society's best interest to release that information to an individual just because that individual acts. And I know counsel keeps referring it to as plaintiffs. The defendants maintain that there really is only one plaintiff, and that's this plaintiff Brady, who has requested this information. And again, without questioning his motives, we are left to be, the county has been put in an untenable position because on one hand, plaintiff Brady is telling us, hey, you know what, your symptom is compromised, all I want to do is, or could be potentially compromised, all I want to do is verify that everything's good. And in the same rate, the defendant has been expected to rely on those representations of plaintiff that, hey, you know what, he's the good guy. He's not the bad guy. This isn't a Trojan horse whereby he's going to be able to mess up the upcoming election. And that's why the timeline is even more important to the county, because we have an election coming up in a couple of weeks. If the court orders to release this, call it metadata, call it whatever the court wants to call it, but if we're ordered to release the network settings, the program file folders, the audit logs of over a dozen computers that are wirelessly connected for the upcoming election, that's a real credible problem, and it's a serious concern that the defendants have, where this information can be, what can be done with this information, not necessarily in the hands of this plaintiff, but that is a concern, but any other plaintiff that simply because they decide that it is the people's records, it's the people's information, that it is in society's best interest to release that. And that's the concern that the defendants are taking at this point. We're not trying to stonewall this. We're not even trying to say that this information should ultimately be disclosed. We're saying that at this point, we need somebody's direction that it's not going to cause a problem to release this information. And the plaintiff's word at this point is insufficient, because again, we can't understand what is going on without having that technical background and the efforts to ascertain that. We haven't been able to do it yet, Your Honor. So I sound like I'm renewing my motion to continue, and in a way I certainly am, Your Honor. And I'm also renewing my request for a master who has the technical background. I don't believe, I don't know the court's background, but we're dealing with program files, we're dealing with code sourcing, and again, code hasn't been requested, but that's a pretty fine distinction, and nobody within the county has been able to give the positive thumbs up that it's okay to release this without causing potential problems. And as I mentioned earlier, we're not dealing with the problems, we're dealing with the appearance of problems. And that's of concern to the county as well, and particularly the Board of Supervisors wants to make sure that the public has trust in the electoral process and has trust in the systems that have been put in place so that people's vote counts and only count once. And that's the defense position that you're at this time, Your Honor. Thank you.